My daughter-in-law handed me an eviction notice the same morning we buried my son. Not a conversation, not even the decency of eye contact. Just a white envelope slid across the kitchen counter while I was still wearing my funeral clothes. And she said, "The lawyer says 60 days is the law. I'm giving you 30 out of respect for Michael." Respect. She used that word. I'm Everett Caldwell. I'm 64 years old. I spent 31 years as a commercial real estate attorney in Columbus, Ohio. And I know exactly what respect looks like. What she handed me was not it. But here's what my daughter-in-law didn't know when she slid that envelope across my kitchen counter. And I want to be very clear that it was my kitchen counter, in my house, on my land. She didn't know that the building she'd been living in for the past 6 years was titled to a family LLC I'd formed in 2003. She didn't know that my son had never owned so much as a square inch of it. And she absolutely did not know that the $740,000 she'd already started mentally spending, the life insurance policy she'd been on the phone with the broker about before we even left the cemetery, had a beneficiary she'd never thought to ask about. She was about to learn that quiet men who spent 3 decades reading fine print are very dangerous people to underestimate. Let me go back to the beginning, because the beginning matters. Michael was my only child. His mother, Caroline, passed from pancreatic cancer 9 years ago, and after that it was just the two of us for a while. He was 26 when she died. We leaned on each other in ways fathers and sons usually don't have to. I cooked. He fixed things around the house. We watched football on Sundays and didn't talk about how much we missed her, because we didn't have to. He met my daughter-in-law 3 years later at a conference in Chicago. She was a pharmaceutical sales rep, smart, driven, polished in that particular way that makes you trust a person before you've had any real reason to. Michael called me the night after they met and said, "Dad, I think she might be the one." He had his mother's instinct for certainty. They were married 14 months later. I paid for the wedding. Not because Michael asked me to, but because Caroline would have, and I was doing everything I could to be both of them for him. They moved into my house on Birchwood Drive in Gahanna, the house I'd bought in 1998, renovated twice, and paid off entirely by 2011. I offered it to them because the house was too big for me alone, because the commute to Michael's firm was 12 minutes from the front door, and because I could keep an eye on things. I moved into the converted studio above the detached garage. Gave them the main house. Didn't charge rent. For 6 years, I watched my daughter-in-law treat that generosity like an inheritance she'd already earned. She redecorated every room except the one with Caroline's china cabinet, which she moved to the garage. When I brought it back inside, she moved it again. When I asked if we could talk about it, she said Michael had agreed the aesthetic wasn't cohesive. I let it go. Michael was working 60-hour weeks at his structural engineering firm and came home exhausted. I wasn't going to add to his load. The second sign came about 2 years in, at a neighborhood block party. I overheard her telling our neighbor Patrice that she and Michael were planning to expand the property eventually. Expand what property? I remember thinking. But I smiled and refilled my lemonade and said nothing. The third sign came last Thanksgiving, when she introduced me to her sister's husband as Michael's father. He lives on the property. Lives on the property. Like I was a groundskeeper. Still, I said nothing. Michael was happy. The marriage seemed solid. I had learned from 31 years of contract law that you pick your battles based on what's at stake, and for a long time, nothing was actually at stake. Then Michael's car was hit by a semi on I-270 on a Tuesday morning in October, and everything changed in 4 minutes. He was 41 years old. He coached Little League on Saturday mornings and called me every Sunday night and still laughed at the same 3 jokes I'd been telling since he was 12. And then he was gone. And I was standing in a hospital corridor being told by a woman in scrubs that they had done everything they could. My daughter-in-law arrived at the hospital 20 minutes after I did. She cried. I believed the grief was real. I still do, actually. That part was real. What came next was not grief. What came next was strategy. She took over the funeral arrangements completely. I suggested the hymn Caroline and I had played at our own wedding. Michael had loved it, requested it once at a Christmas service, and she said it was too old-fashioned for the service she was envisioning. She ordered lilies when Michael had always said lilies smelled like hospitals. She chose a mahogany casket that cost $14,000 and mentioned the price to 3 separate people at the reception, the way you mention a number when you want credit for spending it. At the reception, held in my house, with food I had largely arranged and paid for, she pulled me aside in the hallway near the coat closet and lowered her voice. "Evad, I've been thinking about next steps." I waited. Obviously, this house will be going through probate. Michael's estate. I've already spoken with a probate attorney, and she says the process is fairly straightforward given that we don't have children. I looked at her for a moment. "What house are you referring to?" "This house." She glanced around like the answer was self-evident. "Birchwood Drive. Michael's estate includes the house, and as his wife, I'm the primary beneficiary." "Michael didn't own this house," I said. She smiled the way people smile when they think you're confused. "Eva, I know this is a hard day. We can talk about the details later." "The details are that this house is owned by Caldwell Family Properties, LLC, which I formed in 2003. Michael was never on the deed, not once." The smile stayed, but the warmth went out of it. "I'm sure that's something we can sort out with the attorneys." "I'm an attorney," I said. 31 years, commercial real estate." She excused herself to greet another guest. That was a Tuesday. By Thursday morning, the envelope was on my counter. I sat with it for a while, made coffee, read it twice. It was actually drafted by a real attorney, which told me she'd moved quickly. The letter cited Ohio Revised Code and referenced Michael's estate assets and my status as a non-owning occupant. It was almost admirably aggressive for someone who hadn't done 30 seconds of title research. I had a filing system in the studio above the garage. 31 years of professional habit. Every LLC document, every operating agreement, every property tax statement going back to 1998. All of it organized in archival boxes by year and category. I also had a binder specifically labeled Birchwood Drive Title and Finance that I updated every January. I opened it on Thursday afternoon and spent about 40 minutes reviewing what my daughter-in-law was about to find out. Caldwell Family Properties, LLC, formed October 2003, sole member Everett James Caldwell. The property at 412 Birchwood Drive had been transferred into the LLC in 2004 for estate planning purposes, a move every estate attorney had been recommending to small property owners since the late 90s. Michael had known about it. I'd explained it to him when he was 22, sitting in this same studio, and he'd nodded and said, "So the house is protected?" And I'd said yes. And he'd said, "Good." And that had been the end of the conversation. He trusted me with the financial architecture of things. That was our arrangement. She had never asked. In 6 years of living here, she had never once asked whose name was on the deed. There was more in the binder. The property tax invoices paid annually from my personal checking account. The homeowner's insurance policy, Everett Caldwell, named insured. The original purchase agreement from 1998. A 2019 appraisal I'd had done when I was considering a refinance, showing current value of $485,000. My name on every single page. And then there was the other document. The one at the back of the binder in a manila envelope I'd sealed and labeled, Life Insurance EJC, Michael 2018. Michael had a $740,000 term life policy through his firm. She knew about it. She'd referenced the amount when she was on the phone with the insurance broker 2 days after the funeral, which I knew because she'd taken the call in the kitchen while I was sitting on the porch and the window was open. What she didn't know was that Michael had called me in 2018 and asked me a question. He'd said, "Dad, I want to set up the insurance so it goes to the right place if something happens. What would you recommend?" And I'd said, "Name the LLC as beneficiary. It protects against probate, it keeps the asset controlled, and if you," and I'd paused, "it just keeps things clean." He'd said, "Okay." We'd updated the beneficiary designation together at his kitchen table on a Sunday afternoon. The beneficiary on that policy was Caldwell Family Properties LLC, which meant the beneficiary was me. She had been mentally spending $740,000 for 4 days. Not $1 of it was hers. I thought about calling her. Thought about it seriously. I could pick up the phone, explain the LLC structure, show her the documents, and we could have a real conversation about what the next steps actually looked like. Reasonable people did that. But then I thought about the envelope on my counter. 30 days. I thought about Caroline's china cabinet in the garage. I thought about, he lives on the property. I thought about a $14,000 casket chosen to impress people at a funeral reception. I called my colleague instead. Adrian Foss had been a probate and estate litigation attorney for 26 years. We'd referred shared cases for 15 of them. I explained the situation in about 8 minutes. He was quiet for a moment and then he said, "Everett, she served you notice in your own house, correct? And she's already initiated the insurance claim." "Apparently." Another pause. "When do you want to move?" "Give her 1 more week," I said. "I want to see what she does with it." She used the week productively. She had an interior designer come through the house on Saturday. I watched from the studio window as a woman with a measuring tape walked room to room while my daughter-in-law pointed at walls. On Sunday, she had brunch with what appeared to be 2 of her colleagues from the pharmaceutical company, and I overheard the words "fresh start" and "finally have the space to do something with it" through the screen door while I was watering the planters on the studio steps. On Monday, she called the insurance broker again. I know because she still hadn't fully closed the kitchen window. Tuesday of the following week, I put on the suit I'd worn to Michael's funeral and drove to Adrian's office on North High Street. We laid the documents across his conference table. The LLC formation papers, the operating agreement, the deed showing transfer to Caldwell Family Properties in 2004, 26 years of property tax records, the insurance policy with the beneficiary designation. Adrian reviewed each item with the focused quiet of someone who is composing a document in his head while he reads. "Clean as a whistle," he said finally. "It was a clean transaction," I said. "I'm an attorney. I did it correctly." "What do you want the outcome to look like?" I'd been thinking about that question for a week. "I want the insurance claim redirected to the LLC immediately. I want her served with a formal notice that she is a licensee, not a tenant, not an heir, not an owner, and that her license to occupy terminates in 60 days. I want everything documented so there is no ambiguity and no room for a counterclaim." "And what about the audience?" Adrian asked. He'd known me long enough to know when I was thinking about something beyond the legal mechanics. "She told her colleagues she was inheriting a house worth nearly $500,000, I said. "She told the insurance broker that the policy money was hers. She's been telling anyone who would listen that I'm a retired old man who's been living off my son's goodwill." I straightened the papers on the table. "I think the correction should happen in a place where the same people can hear it." Adrian almost smiled. "Where?" "She has a regional sales meeting Friday morning at the Marriott on Eastern. I know because it's in the shared calendar she never removed me from." He did smile then. "I'll have everything ready by Thursday." Thursday evening, I called her. I told her I needed to discuss the property matter, and that I'd prefer to do it in person, with her colleagues present as a courtesy, so there would be no misunderstanding afterward. She said that was unnecessary and slightly strange. I said I understood, but that I would be there regardless, and that it might be better to have the conversation willingly than to have Adrian serve her the documents in front of her regional director without context. There was a long silence. "Fine," she said. 9 o'clock. Friday morning, I arrived at the Marriott at 8:50. Adrian was already in the lobby with his briefcase. We found the conference room they'd reserved. About 12 people were setting up coffee and arranging folders. My daughter-in-law was at the front of the room with a colleague, reviewing a slide deck. She saw me come in, and her expression did something complicated. Devastated. "You brought an attorney." "This is Adrian Foss. He handles estate and property matters." Her colleague, a regional manager type in a navy blazer, looked between us with the polite concern of someone trying to assess whether this was going to be a problem. "We can step into the hall," my daughter-in-law said quickly. "I'd prefer to stay here," Adrian said pleasantly. "It'll only take a few minutes, and frankly the context may be useful for anyone who's been involved in planning discussions about the property at Birchwood Drive." Two of her colleagues exchanged a glance. I recognized the look. They'd heard about the house. Adrian opened his briefcase and set 3 documents on the conference table. "The first document," he said, in the measured tone of a man who had done this many times before, "is the operating agreement for Caldwell Family Properties, LLC, formed in October 2003. The second is the deed for 420 Birchwood Drive, Gargana, Ohio, showing transfer to that LLC in April 2004. The third is the beneficiary designation for Michael Caldwell's term life insurance policy, naming Caldwell Family Properties, LLC as sole beneficiary." He looked at her calmly. "None of these assets are part of Michael Caldwell's probate estate. None of them were his to bequeath. The property belongs to the LLC. The insurance proceeds belong to the LLC. The LLC's sole member is Everett Caldwell." The room was very quiet. My daughter-in-law picked up the deed. I watched her eyes move across it. I watched the color leave her face in the particular way that happens when someone realizes not just that they were wrong, but that they were wrong loudly and in front of people who now knew it. "This can't be right," she said. It was almost a whisper. "It is documented and recorded with the Franklin County Recorder's Office," Adrian said. "We pulled the public record this week. You're welcome to verify." "Michael told me." She stopped. "Michael lived in his father's house," I said. I kept my voice even. He knew that. I told him when he was 22. He was proud of the arrangement. He said it meant the property was protected. I paused. "He may not have thought to explain the details to you. That's a conversation you might have needed to have with him, or with me, at any point in 6 years. Her colleague in the navy blazer was very studiously looking at the slide deck. "The insurance money," she said. $740,000. "I already told the broker." "We've already contacted the insurance company," Adrian said. "The claim has been redirected to the named beneficiary, the LLC." She sat down. Just sat down right there in the conference chair, in a room full of her colleagues, and put the deed on the table in front of her. "I didn't know," she said. "You didn't ask," I said. "That's different." "I assumed." "I know what you assumed. I heard most of it through the kitchen window." A few of her colleagues were no longer pretending to look at the slide deck. Adrian set a 4th document on the table. "This is a formal notice of license termination. As a licensee of the property, not a tenant, not an owner, your right to occupy terminates 60 days from today. That gives you through the end of January." He looked at her with professional neutrality. "Is there anything you'd like to discuss regarding the timeline?" She didn't answer for a long moment. Then she looked at me, really looked at me, maybe for the first time, and said, "Where am I supposed to go?" "You're a capable woman with a good career," I said. "I imagine you'll figure it out. I would have helped you if things had gone differently. I would have given you time, helped you transition, made sure you landed on your feet. That's what Michael would have wanted." I stood up and straightened my jacket. "But you handed me a 30-day notice while I was still wearing my funeral suit. So—" I let that sit. Adrian closed his briefcase. We thanked the room for their time, I meant it genuinely, and walked back through the lobby and out to the parking garage. The consequences arrange themselves without any further effort from me, which is usually how it works when the foundation is solid. The insurance broker called Adrian's office the following Monday to confirm the claim redirection. The regional director of my daughter-in-law's company, the man in the navy blazer, whose name I later learned was someone she told the house story to 3 separate times over the previous month, asked her to take a temporary leave while they reviewed some compliance questions about a client account. I don't know the details, and I didn't ask. That situation was entirely unrelated to me. 2 of her friends came by the house separately that week, presumably to assess the situation or offer support. I offered both of them coffee and answered their questions directly. Yes, the house was mine. Yes, it had always been mine. Yes, Michael had known. No, I harbored no hostility toward anyone. I was a 64-year-old retired attorney who had lived simply since his wife died and his son grew up, and I would very much like my kitchen window closed when phone calls were being made, and other than that, everything was fine. My neighbor Patrice, who had heard the expanding the property comment at the block party 4 years earlier and had not forgotten it, brought me a casserole on Wednesday and told me the neighborhood was on my side, which I hadn't asked for but appreciated. My daughter-in-law moved out on a Saturday, exactly 58 days after the meeting at the Marriott. I know the date because I was sitting on the studio steps with coffee when the moving truck pulled up. She had rented a 1-bedroom in Westerville, which was a reasonable choice, close to her office, good neighborhood, manageable on her salary. She came to the studio door before the truck pulled away. I hadn't expected that. "I want to apologize," she said. She was not crying. I respected that. Not just for the notice, for the way I spoke about you. To people. For a long time. I nodded. "Michael talked about you constantly," she said. "How you built things, how you planned things, how you always had the document you needed in the right folder." She almost smiled. "I think I was intimidated by that and I handled it badly." "You handled grief badly," I said. "Most people do." "I handled more than grief badly." "Yes," I said, "you did." She looked at the house, the crown molding I'd had replaced in 2015, the front porch I'd rebuilt, board by board, the summer after Caroline died. "I didn't understand what I was living in," she said. "I thought it was Michael's. I thought I understood the situation." "You thought you understood it because you didn't ask the questions that would have complicated the answer you'd already decided on." She was quiet for a moment. "That's fair." "If you'd asked," I said, "on any given Sunday in 6 years, just asked, 'How does this work? Whose name is on this?' I would have told you everything. I would have walked you through the LLC structure, explained the insurance, made sure you understood where you stood. I wanted you to understand. Michael was building a life with you, and I wanted you to be part of a foundation you could actually trust." I paused. That conversation just never happened. She looked down at the steps for a moment, then back at me. "Do you think Michael knew I didn't know?" That was the question I'd been sitting with for 2 months. The honest answer was probably not. Michael trusted that the people he loved would talk to each other. He was his mother's child in that way, assumed goodwill, assumed communication, assumed that the people around him were curious about each other in the same open way he was about everything. "I think Michael thought you two had talked about it," I said. "He wasn't a man who assumed the worst about people." She nodded once, then she held out her hand. Not a hug, a handshake, direct and unambiguous, the way you acknowledge something that happened and name it without pretending it away. I shook it. She walked back to the moving truck. I finished my coffee. The truck turned out of the driveway, and I sat for a while in the November quiet, listening to the neighborhood, someone's dog, a leaf blower, 2 houses down, the sound of Patrice's wind chimes in the first cold breeze of the season. Caroline's china cabinet was back in the dining room. I'd moved it there the afternoon after the Marriott meeting, set it exactly where she'd had it, straightened the little brass feet until they lined up with the grain of the floor the way she used to. I thought about what I'd learned, not about LLCs or probate or beneficiary designations. I'd known all of that. What I'd learned was simpler and harder to articulate. I'd learned that the people who stay quiet are not always the ones without power. Sometimes we're the ones who understand exactly where the power is and choose not to reach for it until reaching becomes necessary. Michael taught me something about that, actually, without ever knowing he had. He never needed to announce what he knew or what he had. He just showed up, consistently, and built things and trusted that the foundation would hold. It held. If you're watching this and you've ever been written off because of your age or you're quiet or the fact that you drive an old truck and don't talk about money at dinner, I want you to know that the people who underestimate you are writing a story about you that you haven't finished yet. You get to write the ending. Sometimes the most powerful thing in the room is the thing no one thought to look for. Sitting on the studio steps the morning the moving truck pulled away, I didn't feel like I'd won anything. That's the part nobody tells you about when they talk about standing up for yourself. The aftermath isn't triumph. It's just quiet. A different kind of quiet than the grief, but quiet all the same. What I kept coming back to was a simple thing my father told me when I passed the bar exam. He said, "Evida, the law will only protect what you've already built correctly." I was 26 and thought he meant file your paperwork on time. I understand now that he meant something larger. He meant that the life you construct, the habits, the honesty, the care you put into every document and every relationship, that's the thing that stands up when everything else is being questioned. You can't improvise integrity in a crisis. You either built it or you didn't. Everett spent 31 years building it. Not loudly, not in a way anyone would notice unless they looked carefully. He drove an old truck and wore the same suits and kept his files in archival boxes labeled by year. And when the moment came that required him to produce 30 years of evidence of who he actually was, it was all there. Every page. That's not luck. That's a kind of moral seriousness that most people only recognize when they're sitting across a conference table from it. My daughter-in-law isn't a villain. I've had time to understand that. She made assumptions that her own grief made feel like certainties, and she moved on those assumptions without asking the questions that would have slowed her down. That's a failure of something. Not cruelty exactly, but a failure of the kind of intellectual honesty that good decisions require. The willingness to say, what do I actually know here, versus what am I assuming? She was a smart woman in a professional field that requires attention to detail, and she still didn't check the deed on the house she'd lived in for 6 years. That's what assumptions do to people. They feel like knowledge right up until they don't. What stayed with me most, though, and I've turned this over many times since November, was the question she asked before the truck pulled away. She asked whether Michael had known she didn't know, and the honest answer was that Michael trusted the people he loved to talk to each other. He believed in goodwill, the way some people believe in gravity, as a given, not something you had to verify. He got that from Caroline. I think the hardest thing about losing someone like that is learning to carry their belief in people when your own faith in it has been tested. Michael never needed protecting from his own optimism. It was one of the finest things about him. My job now is to not let one bad season turn me into someone who stops trusting carefully. Not blindly, but carefully. That distinction cost me a great deal to learn. If you've ever been underestimated, I want to say this directly: the work you do quietly, the standards you hold when no one is watching, the way you document and prepare and show up without needing credit for it, that is not invisible. It accumulates, and when the moment arrives that requires you to be exactly who you've been all along, it will be there. Build the foundation. Do it right. The rest will speak for itself when it needs to.